Your Honour, if it pleases the Court, my name is Scales, initial S, and I am here today to represent the defendant, Mr. James Beatson. Mr. Beatson is charged with 5 counts of breaking and entering a premises to commit an indictable offence and 32 counts of burglary. There are evidential grounds to exclude the evidence against my client under a Section 590 AA argument to be heard before Your Honour today. The defence moves to exclude my client's admissions from evidence on the basis of 3 grounds that contravene public policy and procedural fairness, rendering my client's admissions wholly unreliable and inadmissible. Your Honour, Mr. Beatson is a 14-year-old boy who is Indigenous and currently resides in Townsville. His age and cultural background ought to have been considered prior to questioning pursuant to Section 420 of the Police Powers and Responsibilities Act, Queensland. Section 421, subsection 2 of the Police Powers and Responsibilities Act, Queensland states that prior to questioning, officers must not question a child unless, before questioning begins, if reasonably practicable, the child is afforded the opportunity to speak to a support person of their choice in circumstances in which the conversation will not be overheard. The support person supplied within the questioning was a social worker who was unknown to the defendant, nor was he chosen by him. He was told by this very social worker to do as the police tell you, they're just doing their job. Except in this instance, police officers were not acting in good faith, nor were they acting according to procedure. My client should have been afforded the opportunity to speak to a support person of his choice. This person could have been an individual, independent person and able to act in the best interests of Mr. Beatson. Although the Crown may argue that a support person was present during the formal questioning, in which my client was formally interviewed, this support person was not present when the police initially began to question him at the school and when they began to drive him to 32 different properties and then asking him, did you break into those houses? At the initial time officers moved to question my client, they should have followed proper procedure and allowed Mr. Beatson to speak to a support person. Instead, the police took my client on a fishing expedition on the scenic drive from property to property, from crime scene to crime scene. Furthermore, Mr. Beatson is an Aboriginal child whose cultural differences were exploited by the arresting officers. During the drive with officers, my client nodded his head in agreement and verbally agreed when asked, did you break into those houses? It is customary for speakers of Aboriginal English to use an indirect approach to communication and exchange in an open dialogue. My client's agreement to the officer's questioning is a clear example of gratuitous concurrence. Gratuitous concurrence is described by the Equal Treatment Benchbook of the Supreme Court to be the tendency to agree with the questioner, regardless of whether or not the Indigenous person agrees or even understands the question. Gratuitous concurrence is deeply rooted in the Indigenous socio-cultural context. The case of Purcell and Vandernoes highlights the difficulties Indigenous persons face when differences in cultural communication are exploited. These cultural differences have arguably led to my client's admissions of guilt to have a low probative value, whilst also having a highly prejudicial effect, as in the case of Hassler. The arresting officers were also in direct violation of Section 431 of the Police Powers and Responsibilities Act, as they failed to caution my client that he had the right to refuse to answer any questions or make any statements unless he wished to do so. Furthermore, the officers should have confirmed that he understood this right, being that he is a child and being that he is Indigenous. If necessary, the police officer must further explain the caution under Section 431, subsection 4 of the Police Powers and Responsibilities Act. Due to the arresting officer's failure to caution my client, Mr. Beatson was allowed to incriminate himself under unjust circumstances. As in the case of Bunning and Cross, the defence humbly believes it has proven the misconduct of the arresting officers who were in direct violation of statute. The cogency of the Crown's evidence has a low probative value due to the fairness discretion, and it is clear that the conduct of the officers was not a genuine response to pressing circumstances. Your Honour, the gravity of the charge against my client is that of a non-violent nature, and it is clear the arresting officers blatantly disregarded public policy in this instance, as well as statute. Your Honour, I ask you to consider Section 130 of the Evidence Act, and respectfully ask you to exercise judicial power and reject the Crown's evidence on the basis it was procured in such a way that undermines our criminal justice system, procedural fairness, and public policy. If my client's admission was allowed into evidence, this sets a dangerous precedent, as the officers whom obtained my client's admission did so under violation of their duties and statute, which is prejudicial in its very nature. Mr. Beetson deserves procedural fairness, which is at the heart of our criminal justice system. This concludes the defence's submissions. Thank you, Your Honour.